Getting in some breaking inputs, this with regards to the 2002 Gujarat Riots. The Supreme Court has now granted bail to Teesta Setalvad. The court has noted that evidence is already with the prosecution, hence no question of tampering of the evidence arises. The Supreme Court has also said that Teesta's custodial interrogation is now not necessary. For more details, we'll quickly go across to Ananya Bhatnagar, who's joining me on the phone line. But in the meantime, this is a big decision coming in from the Apex Court, which has finally granted bail to Teesta Setalvad. The court has noted that the evidence is already with prosecution. Remember, she was accused of tampering with evidence with regards to the Gujarat riots, and that's what the Supreme Court is now stating, that hence, since the evidence is with prosecution, there is no question of tampering of the evidence. The Supreme Court has also said that Teesta's custodial interrogation will not be deemed necessary anymore. Ananya is now on the phone line with us. Ananya, going by what the Supreme Court has said, this clearly seems that they've come down heavily on the Gujarat High Court's order. Take us through what the Supreme Court had to say.
Well, definitely, the Supreme Court has completely set aside and quashed the orders passed by the Gujarat High Court single-judge bench, and in fact has said that, the order was, certain observations in that order were perverse, especially with regards to, there was specific observations made by the Gujarat High Court that since Teesta had not challenged, in fact, the sections that were levied against her in a 482, that is a quashing petition, and that was one of the reasons why, in fact, the Gujarat High Court had denied her bail. The Supreme Court clearly said that this observation is perverse and has now quashed the orders of the Gujarat High Court, clearly giving a big relief to Teesta Setalvad in this particular case of evidence tampering and fabrication of witnesses into this particular case. But at the same point of time, we have to also remember that there are certain conditions that have been imposed on Teesta Setalvad. Into this, she has been asked to not contact or to be close to any kind of witnesses into this particular case, though the evidence is with the prosecution, but she shall not also tamper with the evidence in this particular case, and in fact should be remain in touch with the investigation officer. These were the general conditions that have been laid, and in fact the whole order of the Gujarat High Court has been turned down by the topmost court of the country, clearly saying that since already a charge sheet in this matter is particularly filed, there is no kind of custodial interrogation that is required, and hence she deserves to be given out a bail in this particular case.
Right, Ananya, another important observation in the court's order is the fact that they've also highlighted how considerations for Teesta's bail were not adequately considered by the Gujarat High Court. Take us through what the High Court, what the Apex Court has had to say with regards to the High Court.
Well, there were certain discrepancies with the High Court order that the Supreme Court actually highlighted. When the detailed judgment of the court would come out, we'll get to see the exact portions of the order that have been challenged. But these were basically with regards to how the High Court had given out an observation that, a person who has applied for a bail and not challenged the sections under 482, that is for a quashing of those particular sections, are not entitled or are not challenging the sections against them. That means there is a prima facie case against them. That the High Court believed, the Supreme Court believed that this observation is something that is factually incorrect and is not according to the law, and hence that observation has been turned down. In fact, the whole order of the Gujarat High Court has now been turned down by the topmost court of the country. But definitely the trial in this case would continue, though Teesta would remain to be out on bail in this particular case until and unless there is a framing of charges and the orders are passed and trial is started in this particular case.
Right. Another important point over there arising is that there will be no need